Hello, everybody. Good morning or good afternoon, depending on where you happen to be sitting. Thanks for joining us today. My name is Mike Gibb. I run accountsrecovery.net, and I want to welcome you to today's webinar on FDCPA litigation trends in 2021. Yesterday, we spent an hour talking about the TCPA and what's going on with that. Today, we're going to talk about what's going on with the Fair Debt Collection Practices Act. We've already seen an increase in the number of lawsuits, and that was before the 11th Circuit's decision in Hunstein that came out a few weeks ago. But even outside of that ruling, there are other trends that collectors should be aware of. So today in this webinar, which is being brought to you by TCN, we have a panel of legal and compliance experts from both sides of the beer here to break down the trends they are seeing in the FDCPA to help you better understand what you should be looking out for. Before introducing the panel, I'm going to give my usual spiel about the accountsrecovery.net Slack channel. Still don't know why everyone hasn't signed up for this. There's a link in the chat window if you haven't done it already. Completely free, doesn't cost you anything. I think we're just at about 600 members now who are using the channel to stay in touch with one another, to network with one another, to kind of keep an eye on what's going on in the industry. So I encourage everybody to sign up and join if you haven't done so already. Guarantee you it's going to be worth all the money you have to spend to join, which is nothing. Now let me introduce you to today's panelists. Mike Cardoza is a former senior executive of a debt buying company, a debt collection agency, and a regional high volume debt collection law firm. But now he's the author of The Secret World of Debt Collection, Beat Collectors at Their Own Game, and is regularly featured a speaker and commentator on consumer rights and credit reporting. Joe Messer is a partner with Messer Strickler, a law firm which concentrates in defending collection agencies, debt buyers, lending institutions, and credit reporting agencies and others in consumer lawsuits brought under state and federal consumer protection statutes. Joe's nationally recognized in the area of consumer litigation defense at the trial and appellate levels. He has been lead counsel in many class action lawsuits brought under state and federal consumer laws, including the FDCPA, FCRA, and TCPA. Judd Peak is the Chief Compliance Officer at Capital Accounts. He brings more than 2 decades of experience and is recognized as a leader for ARM in the ARM and revenue cycle compliance industries, with a particular emphasis in healthcare. Judd has built compliance programs at 2 ARM companies. He has honed particular expertise in healthcare privacy, patient payments, and industry best practices. Brooke Teal is a lead attorney at Lloyd & McDaniel, where she represents both creditors and debt buyers in multiple states. She has extensive attorney fee litigation experience, primarily in Florida, and previously worked as in-house counsel for 2 of the top 5 debt buyers in the nation. Brooke is heavily involved in the creditors' rights communities, previously serving as Florida Creditors Bar President and Secretary of the Florida Small Claims Rules Committee, and is licensed in Alabama, Florida, and Georgia. Our format today is going to be our usual panel discussion. As usual, we encourage everybody to submit questions, and we'll get to them during the course of our conversation. To do so, to submit a question, you can do so doing one of 2 ways. Either send it to us through the Q&A tab on your Zoom webinar control panel, or send it to us through the chat window. Since we're going to be talking about compliance today, let me read the following disclaimer. This presentation is not intended to be legal advice and may not be used as legal advice. Legal advice must be tailored to the specific circumstances of each case. Every effort has been made to ensure this information is up to date. It is not intended to be a full and exhaustive explanation of the law in any area. It should never be used to replace the advice of your own legal counsel. With that, let's now ask everyone for their legal advice. All right, so let's we're going to talk about Hunstein. Let's talk about it. Let's, as Joe said, as we were getting ready for this, we're going to spend a little bit of time on it, but there's plenty of other things to talk about. So Joe, why don't you sort of just walk us through where we are with Hunstein and what, maybe talk about what you see in terms of where it's going to go from here.
Sure. So I'm sure, as everybody knows, this is a case having to do with whether sending letters to a collector sending letters to a letter vendor constitutes a third-party disclosure in violation of the FDCPA. Obviously, an earth-shattering case. The court held that it did, and now we've got lots of people scrambling to deal with it, because it was acknowledged even in the case that was standard operating procedure. So now we're calling into question whether this can be done. All I can really tell you, there are lots and lots of arguments in defense, things that were not raised at all in that case, which is unfortunate and maybe part of the reason it got there. I could tell you that we're seeing many, many cases filed. Our firm is seeing most of those lawsuits filed in Florida and in New York. We know that we haven't really seen anything in Chicago yet. We know they're coming just from kind of listening to the drum beats and talking to people. And the strategy for defense is really not clear. There are a lot of different approaches people are taking. You know, obviously you can make the arguments that were not made in that case. One of the primary ones, I think, is that the letter vendor is just an agent of the collector. So there's a good argument there. But the other thing that's kind of interesting is, and this kind of plays into the standing issue, we're going to be talking about some standing cases. We feel that there's really are some good arguments for lack of standing in those cases because of any lack of damages that the plaintiffs would incur as a result of that scenario of a letter vendor receiving a letter or information regarding a debt. And in fact, the court in Huntston even talked about that, but didn't actually land on that. There are real issues about that, though, whether you want to do it. And the primary issue is whether there's a survival statute that's available in the particular state in which you are dealing with. If there is, we don't feel that makes a lot of sense because the plaintiffs would most likely just refile that lawsuit in state court. So we would say that it may make more sense to develop the record in those cases, develop the fact that there's not standing because there's no injury as a result of that purported third-party disclosure, and then perhaps bring a motion to dismiss later in the case. But again, it's just very, very new right now, and there are lots of different considerations, and I'd say everything's case by case at this point.
Okay. Judd, Brooke, Mike, anything else we want to add on top of Hunstein before we kind of move on to some of the other things that we wanted to talk about today?
Sure, I'll chime in. Just coming from the agency's standpoint, and trying to, caption this in the title of this webinar, the litigation trends and where this might be trending. It's hard to trend out because it's so new, obviously. But where I'm seeing it with the copycat cases that have been filed right now, Consumer Board is trying to expand the rule, which is right now limited to the 11th Circuit, to 3 states, to expand that broader. Really, it causes me to have kind of a twofold strategy in my head. We don't have one of these cases yet, but trying to on the front side, trying to go ahead and get established what our strategy is going to be. And I'm looking at, if it's in the 11th Circuit, then there's a motion to rehear that is coming, and if we get one filed against us, then want to stay it and let the Hunstein case play out. It's in a different circuit, then right now it's not interpreted anywhere outside of the 11th Circuit. So if it's filed elsewhere, it's one that I think should be defended, and I'm prepared to do that if we're the defendant in one of those cases. So I think that's just going to be something that we have to deal with. This is going to be the new reality on this issue of third-party disclosure that the industry is going to have to take a twofold approach with. The trend is going to be that we're having to deal with this. It's going to be an attempt at creating a new area of law and a new area of litigation. So deal with it on the legal side, trying to create good law elsewhere. And then, I kind of analogize it to where the industry was several years ago with the TCPA and the idea of human intervention and having, what is a storage of numbers and et cetera, and coming up with a technological solution to that, which is what a lot of the dialing technologies did. I think we're going to have to find a technological solution to using letter vendors that would not qualify as a third-party communication. I'm not sure exactly what that'll be, but there will be some industry response, especially on the vendor side, as far as how to get around what the 11th Circuit has said.
Okay. We can move on now. Let's talk about some of the other things. The idea for this webinar started before Hunstein, so there's plenty of other things that are going on with respect to the FDCPA to talk about. Joe, you brought up the issue of standing, so maybe let's talk a little bit about that and where we are with some cases, especially in your neck of the woods in Illinois, over the last few months that have addressed the topic of standing.
It's amazing. We're having a sea change in the 7th Circuit on standing. I don't know what happened, but right at the end of last year and into the beginning of this year, we had about 6 or 7 different decisions by the 7th Circuit Court of Appeals that knocked down FDCPA cases on standing. Out of those cases, I think only one was remanded. Every other one, the court determined that the plaintiff did not have standing. And these are cases that they have very similar fact patterns and situations where we've seen the court, that was never even raised by the court before. I don't know whether it's that the defense bar is becoming more aggressive in raising standing and pursuing that avenue, or whether the Seventh Circuit just got tired of technical cases brought under the FDCPA. But it's made a major change in what the case law is, at least in the Seventh Circuit, and we're seeing that in other areas too. Other circuits are picking up on that, and we're seeing more and more standing cases where the defendant wins. I think the biggest concern about this is what I mentioned before, is I don't know that it's going to do you much good if there's a survival statute in the or saving statute in the jurisdiction in which the case would could be brought against. So, like for instance, Illinois has a saving statute which allows somebody whose federal claim is dismissed to bring it in state court. In the state court, under the state law, the standing arguments are very much different. In fact, it's very easy to demonstrate standing. So, and we know that those same laws exist elsewhere, not everywhere, but in other places. So, yeah, you might get a temporary relief and knock out the case. The other thing that is true, though, that some of the plaintiffs' bar is not aware of the saving statutes, either that or they choose not to pursue cases in state court for whatever reason. For instance, Cook County is, we just consider it to be a legal zoo, and it takes forever to get things done. It's very difficult to litigate in Cook County. And so we found that some of the plaintiffs won't actually avail themselves of the saving statute and then won't refile. But that's something that's to be looked at in your particular case.
Okay. Well, Mike or Joe brought up the plaintiff's bar, so I'm going to use that as my opportunity to bring you into our conversation today. From your side of the equation, what are you seeing with respect to standing issues in the FDCPA today?
Well, I mean, I think it's because the Seventh Circuit finally realized that they didn't have to be the strict liability debt collection police, and that they found a way out. It's bittersweet, I think, for the defense bar because, you might like federal practice. You might feel like you have an advantage there, whether it's with rules or the speed of the case or with the jury panel that you might ultimately get. You might not want to be in state court. And so whether you raise it or not, I think you're likely to see, certainly in the Seventh and possibly now in other circuits, the court saying sua sponte, like, sorry, can't be heard here, no standing. So that's one issue. Another is, I think that cases have migrated not from federal court, not just to state courts, but also to arbitration. That again is sort of if you look at it in the long view, that's kind of a double-edged sword. Creditors thought it was really going to benefit them, and then ultimately, the butcher's bill comes due when the consumer files a demand for jams arbitration, and your client's got to come up with like $5,500 before you even get to hello. So the plaintiff's bar has become very comfortable with filing arbitrations and succeeding in arbitrations, and including 5- and 6-figure awards on FDCPA cases from one single arbitrator.
Can I ask, I'm kind of curious to maybe Mike, for you and Joe and Brooke, to kind of get your feedback. But I approach the whole idea of standing, and we haven't really raised that in any cases that we've been litigating or sued upon. But it's a threshold issue, which is whether there's jurisdiction for the court to hear the case, whether the consumer has been injured. There's an injury in fact generally. I don't really think of this as a great get out of jail free card in the long term, because I just think that as we get more decisions from the Seventh Circuit or other courts, the consumer bar is going to start modifying the complaints. They're going to be a little bit more careful about drafting complaints where they do allege concrete injury. And so I really think it's kind of a punting the issue. We're getting some cases knocked out in the short term, but I don't really think of this as being a long-term issue once there's some elevation of the quality of the complaints that get filed. And I'm just wondering if you agree or kind of what your take is, if this is something temporary or permanent.
Can I butt in and talk to that for a second? I'm sorry, I just went, but and I'll stop soon. In preparation for this webinar, and thanks to WebRecon, as always, for keeping the stats and keeping them honest. I wanted to take kind of a retrospective of FDCPA and see, where have we been and where is that, what does the future look like in the context of what the last 20 years is? And I think if you look at the litigation statistics, you can kind of see 20 years ago, this was sort of an infant industry. People weren't quite aware of it. The plaintiff's bar wasn't, too sophisticated about it. Then there became awareness. And then we had this large period of experimentation where, every single permutation of the G notice under the sun was tried, and you just saw a real burst of creativity that I think now has kind of coalesced back down into more of a maturation. So I feel like FDCPA practice has matured. And the reason I wanted to kind of loop back on what you said, Judd, is yes, I think that, you'll find plaintiff side attorneys that do more diligence in discovering whether or not there are actual damages for these clients and whether or not they're reasonably related to the defendant's conduct. And that you'll find more actual damage cases being brought than previous, maybe by different firms, maybe in a different form. But that just because the numbers of FDCPA cases are going down is not necessarily a good thing, because many of them are going, like I said, to arbitration or state court, or maybe they're not recorded. But the cases that do get filed, I think, are going to have a little bit more punch. And remember that one $50,000 FDCPA case costs you exactly the same as 10 $5,000 cases. So it's kind of hard to say, where that's going to balance out. Thanks.
Well, to that point, if we're having more concrete injury cases being filed, where there's more, the exposure level is going to go up a lot more than just a statutory damages case. So I would say, if that's going to be reality, there are a lot more that are going to be litigated, and they become actual. It's not what John Bedard likes to call the death by pinprick anymore, or needle prick anymore, but these are actual litigation exposure issues that we have to deal with and fight or settle larger than probably was the case in the past.
Okay. I'm just going to hit the pause button briefly on our conversation so far. I want to invite McKay Bird from TCN, the sponsor of today's webinar, to say a few words. McKay?
Hi, Mike. Thank you so much, and as well as to the rest of the panelists for making this discussion possible. As Mike mentioned, my name is McKay Bird, and I'm the marketing director here at TCN. What TCN is and what we do is we provide cost-effective call center solutions and compliance management and other services that help power call centers, collection agencies, and as well as thousands of businesses around the world. And yesterday, we just launched a new product or a new platform called Operator. And what Operator is a holistic collection of advanced call center tools that are seamlessly integrated into one cloud-based platform that puts everything into one place and allows for monitoring of operations from virtually anywhere. TCN Operator is highly customizable for meeting all of the needs of the call center or even collection agency. When combined with our no contract experience, and as well as that promise, it provides a maximum flexibility in scaling depending on business conditions. We're very excited to launch this new platform and to be able to help call centers and collection agencies worldwide. So regardless of size, location, or application, we can provide a robust call center or collection platform for your business. And I would invite all of you to go to tcn.com for more information. Thanks, everyone.
Thank you, McKay. And thanks again to TCN for sponsoring today's webinar. I did just put a link in the chat window that will give you more information on TCN's new TCN operator platform. So I encourage everybody to click on that if they haven't done so and checked it out already. All right, Brooke, you're the only one we haven't heard from yet. So, we're going to have to bring you in. For on the topic of standing, is it a case, do you think that should defendants always seek to have cases dismissed for lack of standing, or is that necessarily not a good strategy right now?
I think you have to look at it from a practical matter, not just, legally, can we move it? In this jurisdiction, do you want to be in federal court? Do you not want to be in federal court? I think it's more of an issue as to whether you can do it or whether you should do it. So I think it's kind of a case by case basis and what jurisdiction you're in, who the attorney is on the other side and who the judge is. Where do you want to be? Is there a point making this argument if you actually don't want to be in the other court when you're moving? So I think you need to look at it from like a practical matter as well.
To follow up though, I'm curious, because one of the things that we talked about, I think Mike brought it up, was that some judges are looking at it regardless of whether you bring it up or not. So how do you sort of deal with that dynamic? Is that just something you kind of have to roll with if that happens?
Absolutely. And, maybe they won't refile in the lower court. Maybe they will. But if the judge wants to do it, then the judge is going to do it. So don't really have much of an argument there.
Okay.
Mike, on that point, I think, and we were talking about creativity in pleading and how people will try to plead that, the elements that they need to achieve to make sure that they have standing. I think that gets to the question of when do you move, if you are going to move to dismiss? Because if somebody throws all sorts of allegations in the complaint that get past that, yeah, it's going to be difficult to get the case dismissed. But you can pursue a lack of standing argument at any point. You can pursue that argument on summary judgment. You can actually, believe it or not, you can pursue that argument on appeal for the very first time. So what is important, I think, when you defend these cases is you go through the discovery. If the plaintiff really doesn't have concrete harm type damages, that's going to be an option that's available to you later in the case. So you always want to keep it in mind, and it's just a question at what point do you raise it?
And I do think that's always an issue. We receive so many, baseless FDCPA claims, and the damages is always the issue. Are they actually damaged because they received one letter? Standing is always going to be, at the front of your minds as to whether they were damaged or not.
I think we've covered standing now. Let's move on to our next topic, looking at some of the other letter type lawsuits that are being filed. We've got sort of credit reporting language, language where it mentions the possibility of account being placed with an attorney. We've got letters. We've seen lawsuits with multiple addresses. There just seems to be, like, to Mike, to your point, like it's sort of anything under the sun with respect to the G notice has sort of been tested or attempted to be tested. What should collection agencies or what should collectors be focusing on more? Are there more topics that are more important or more dangerous or more popular than any other right now that you're seeing with respect to FDCPA lawsuits?
Oh my gosh, I'm thrilled. I feel like you might have addressed that question at me, and even if you didn't, I'm grabbing the mic to talk about it anyway. My sense is that relative to now, there was, like, let's say the snapshot, like maybe 5 years ago or maybe 10, there was a sense among consumers or debtors, I got to go back to my own old language. There was a sense among debtors of shame and shame. I'll leave it at that. And it was, maybe they didn't know exactly what the balance was, or they didn't remember exactly what it was for, but they trusted the institutions that told them that they owed a balance, and they felt shame about it, which is one reason why, illegal debt collection tactics were so effective, like parking the red truck out in front of their house. But in the individual mind of the debtor, that shame kind of drove them to hide their problem and to be more acquiescent, I think, to collection efforts, and especially collection threats. And as we have moved forward, in like the digital democratization of life. Like everybody's can find a website for their particular affinity. And it's not just the plaintiff's attorneys that are out there marketing with content. It's about everything. We're now sort of taking back our authentic selves, right? And we're realizing these rights through our phone. I have a right to know what my credit score is at any and all times. And if, Credit Karma is not going to give it to me, then Capital One will. And to land the plane on this, it's that I believe that consumers' attitudes about their relationship with other institutions like creditors has changed. They have an expectation now of continuing to be treated like a customer and someone with power, which they may have. I'm going to do a CFPB complaint on my phone. And they demand like actual communication. And now I'm not talking, if you're an agency owner listening, I'm not talking about you yet, but I'm getting there. You see where it's coming. They're demanding quality, authentic, realistic, case-specific communications with the original creditor. And when they don't get it, they're pissed because they've been personally disrespected. They've been blown off. I called 17 times and they kept giving me the runaround. And the final insult to this is to be placed with collections. Like, I'm just trying to, get some information and you put me in collections. And so that drives them emotionally. And when someone is motivated emotionally, they're going to go find some kind of outlet for that. And typically the content that is put out by plaintiffs' firms is speaking to that emotional feeling. So what happens is these people having an emotional reaction, the ones who are in shame are still back trying to figure out how to borrow money from Aunt Jenny to, pay off your collector by Friday so she can win the steak knives, right? But the ones that are feeling aggrieved by the process are now on the internet looking to see what can be done before they capitulate. And they're finding, hey, figure out if you have a case. And so that gets the attorney involved, which then spots some strict liability, violation by one of your clients or somebody on the webinar right now. And now all of a sudden, what you're dealt with is a lawsuit that is, and you might, use this to your advantage in arguing actual damages. You're dealing with a lawsuit where the consumer is actually pissed at the original creditor, but you're standing in their shoes due to the strict liability of whatever happened. And so now you're in this position where they're, guns for blazing, they've got actual damages, they're emotionally distressed, and you're in the situation of like, can I cave or can I mount a bona fide error defense? And so I just wanted to highlight the fact that I think that consumers are feeling empowered, and that's leading to more filings of more mature cases with actual damages.
Let me make a counterpoint on that, if I may. So I get that, right? You get a consumer that's really upset. For instance, they're very confused by the letter. The letter was not clear, and they thought that they owed less. The letter indicates that they owed more than they thought, and they can't understand how that's the case. I can see how that they could get upset about that. And in fact, that I think is what the model validation letter that that's going to be coming up. In pursuant to Reg F is going to address, and they make an effort to. They do actually require in that itemization, which includes, showing how much interest is accrued, what the amount of the debt is on the date of the letter, that type of thing. Now you can make a lot of arguments about that because I think that's going to be confusing in and of itself. But I will tell you that I think that when you have cases that are involving letters that are not really confusing, not confusing to the unsophisticated consumer, that those aren't going to work. I mean, we've got this DeGroot v. Client Services case in the Seventh Circuit that came down recently. That was, I think that was a case from late last year, early this year. Anyway, that was October of last year. In that case, the court held that the use of an itemized breakdown accompanied by zero balance would not confuse the reasonable unsophisticated consumer. The letter simply said, please note, no interest will be added to your account balance. So, when you have those kind of, I'll just, for lack of a better word, silly claims, that people are misled by a letter, they're not going to work. I would agree, though, that when you have a letter that is arcane and hard to understand, and it shocks the conscience when you read it and look at the amount that's being sought in connection with the debt related to what the debtor thought that they owed in the beginning, then you might have what Mike's talking about.
Kind of to piggyback off that, I think, most of the claims that we see, they're not brought about by the actual consumer. It's their attorney who has looked at the letter and said, oh, I think we might have a claim for this. And they're kind of playing whack-a-mole with each new FDCPA claim and each new case that we have that they can use as a tool. So I agree that I don't think there's that many cases where the consumers are actually damaged. It's kind of the attorneys trying to get fees in that way and trying to make a claim.
I will say, just to kind of, when we're talking about the future of letter cases or letter claims, I don't really see a lot of letter cases in the future. And I'm going to make one exception to that, just because that area of the FDCPA has largely been litigated. We've kind of arrived at what is compliant, what's not, for the most part in the industry. But I think with the advent of REGAF, with the new CFPB rules on the validation notice and requiring the itemization, I think there's going to be a temporary boon in letter cases over that. What specific language on the itemization side is compliant, looking at where you put it, how you word it, all the formatting, stuff that goes into that. There will be some litigation around that until we get to kind of that settled area of the law. There will be an industry standard for various verticals on what works and what doesn't work, and what is legal and what isn't legal under the new regulations. So I'm foreseeing that as being a new batch of letter cases in the next year to 18 months after the enforcement date goes into effect. Short of that, if we're broadening kind of, Mike, your question outside of the just letter cases under the FDCPA, I really am anticipating a trend upwards for third-party disclosure cases. And the reason I say that is for communication purposes, for debt collection. Debt collectors, in order to reach consumers, they're not just down to paper letters and telephone calls anymore. Consumers aren't answering their phone, they're not opening their mail. And we're moving more towards email and texting and even social media and other communication channels. And that's a lot, there are a lot more potholes in third-party disclosure risk when you move into these other communication channels. You don't have the benefit of the postage rule, where you're not supposed to open somebody else's mail. And unlike telephones, where you can, if you get somebody on the telephone, you can confirm their ID before disclosing any information about a debt. An email's an email if it has information about debt in it. Same with text messaging, same with social media, outreach, anything like that. And I think as that becomes more of a settled means of communication with the industry, with collectors, there's going to be that expanded risk involved. Somebody else opened my email, or somebody else received that, or I don't have, that social media account is a shared one, whatever it may be. There's going to be a lot more third-party disclosure claims being submitted. And I really see that small segment of the FDCPA as being ready to increase in the near future.
I definitely see the email being an issue as well. Being in Zoom hearings, the courts are requiring the defendants to say their email addresses over Zoom with 60 people on it. And then we're requiring the law firms to send settlements and agreements to email as well. So I definitely think it's going to create a lot of issues, and we're going to see suits on that.
Okay. Sorry. Yes. Mike, to your point, we've had years on previous webinars. They've sort of said two types of consumers who angry or the bankrupt. You can't really do anything about the bankrupt consumer, but you can do a lot about the consumer. So maybe sort of to this point, saying that a way can possibly avoid FDCPA lawsuits is by sort of trying to deal with those angry consumers before they get to the CFPB before they get to a consumer attorney, or even before they get angry?
I got a little bit distracted. There was some echo for
Yeah, sorry
me
about that.
on the Zoom, and if that was a question for me, could I ask for just a brief rephrasing?
Yeah, sure. Like I said, there's sort of two types of consumers who sue: the angry consumer and the bankrupt consumer. Can't really do a lot about the bankrupt consumer, but you can do stuff about the angry consumer. And I'm just kind of going back to what you were saying. Are you saying that there's an opportunity for companies, collectors, to reduce the number of FDCPA lawsuits they're facing by keeping those consumers from becoming angry and looking at the CFPB or looking to a consumer attorney to help them?
I mean, what's frustrating about being in the collection space is that you're just getting, you're getting what you get from your client. And, however they treated the consumer, if it was with kid gloves or they came to a mutual understanding, you probably didn't get that case for collection. But now you do have that account. And, if they're just kind of a wire brush sort of form letter, go take care of it yourself. Now you're sort of left with the bomb. And that's just a tough spot to be in. So, is there an opportunity from a collection agency point of view to try to rehabilitate that? Yes, absolutely. Email is such an intimate form of communication that I think there's really an opportunity to do social science. And I like to quote Brandon Black from, God knows, maybe 10 years ago now. He says, look, we're not here at Encore Capital Group, we're not trying to solve a financial problem. We're trying to solve a behavioral problem, which is why, I've hired PhDs and so on and so forth. We're trying to get people to put our debt on the top of the list, and people pay people they like. So with, to Judd's point, with this advent of all these new channels of communication with the debtor, there's so much more opportunity to have a more casual but compliant conversation that can take a lot of this anger and steam that you're inheriting from your debtor, which is actually directed at your client, right? Who's the original creditor who placed this account with you. And, you end up kind of dealing with that baggage and diffusing that in order to get to resolution and a payment. I hope that answered the question. It might've just been a monologue.
No, it's okay.
Mike, that's interesting, Mike, Curtis, the comments you made, because I've kind of felt the same way. Our role as a collection agency isn't just to collect accounts. I mean, that's a significant part of that, but I'm fond of saying we resolve accounts. And part of the resolution of the account might not result in a payment, but we've resolved it because we've solved the upset consumer or the confused consumer, whatever it may be. And Mike, to your original question, when you talk about trying to capture those consumers who might be upset, either at us or at the creditor or just at the collection process in general, that's been a strategy I try to employ at all stages. Is I don't want any barriers between a consumer contacting us and communicating with us and attempt to resolve any concerns they may have before going to a consumer attorney or a plaintiff's attorney. So, if that means, we try to work it out with informal resolutions with the BBB or, CFPB complaint channels or anything like that. We've got an open website, we've got open outreach as far as, an ombudsman, for lack of a better term, to try to work out any concerns. And I want a consumer that has an account with us to feel like going to a consumer attorney it's a recourse of last resort. And it should rarely ever get to the situation where we've been unable to address their concerns.
Okay. Judd, you brought up what you think is going to be an increase in third-party disclosure claims, and Mike Cardoza, you mentioned WebRecon. WebRecon's data for March showed a 19% increase in the number of FDCPA lawsuits that were filed in March versus filed in February. Brooke, Joe, everybody else, I'm just curious, on top of some of the things we've talked about already, what else do you think client or companies in the industry should be on the lookout for with respect to, the types of FDCPA lawsuits that they might be seeing either filed against them or just filed against other companies in the industry?
Well, I'd be on the lookout for, these are not FDCPA cases, they're FCRA, Fair Credit Reporting Act claims brought under 1692S-2B of the Fair Credit Reporting Act, which basically it's the provision of the act that requires furnishers of information to credit reporting agencies to report disputes and to not report incomplete or inaccurate information, and to promptly, upon learning of any incomplete or inaccurate information, provide the CRA with that information to allow them to update their records. We're seeing these lawsuits multiply, and just in the last, I'd say they started coming in December, and we're seeing them throughout so far this year multiply. And they're brought by the same folks that bring FDCPA cases. They've just learned that this is a new avenue of recovery, and it's similar to the obligation to report a debt as disputed, but it actually goes beyond that, because the FCRA really requires the furnisher to provide all the information regarding the dispute, or anything that they get, arguably anything that they get from the debtor regarding the dispute, to the CRA. And a lot of agencies really don't have a good mechanism to do that, and they haven't got procedures down to do that. So we are seeing those lawsuits. Importantly, people should bear in mind, though, that the FCRA is not a strict liability statute. It's unlike the FDCPA in that regard. And so there are defenses that are available for violations of the FCRA that don't exist under the FDCPA for that purpose, for that reason. So anyway, that's an area that we're seeing increased an uptick in cases, and something that collection agencies need to be aware of, and to create a mechanism to make sure that they comply with that furnisher requirement.
I'm seeing an uptick in call baiting. So not quite litigation yet, but we want to try to prevent litigation. I'm seeing call baiting asking, do you guys use a letter vendor? Are your collectors educated as to how to respond to that? Do they say, I don't know? You want to make sure your collector is educated and knows what the proper response is to call baiting. So I think, right now, I know we keep mentioning Huntston and everyone's tired of it. But we need to prepare ourselves for that kind of litigation. So that way, when we get there, we're prepared.
Well, to throw a third category under the FDCPA, that these are all unrelated types of claims, but I am seeing primarily, the ones that are asserted or filed or claimed against us and some colleagues in the industry. A lot of claims that come out of dispute resolution process or validation of debts. And my impression is consumers are getting a lot more sophisticated on how to dispute a debt and what to ask for, and sometimes to call out an agency on what their response is. You did not read my dispute. All you did was send me a ledger. And agencies need to really take particular attention to how they're responding to disputes. Are they doing reasonable investigations and providing the information that actually verifies that the debt is owed, and providing the original creditor's name and address and that type of thing. Not being an area of liability necessarily, but I have seen a lot of consumers try to tailor their dispute request, and not just consumers, but consumer attorneys as well. They don't just want verification of the debt or information to verify it, but I want a copy of the original agreement with my signature, or I want a copy of insurance claims that have been filed. If you're talking about medical debt, or financial responsibility parties from the original policies from the original creditor, things like that, which are not necessarily required, but certainly to me it indicates that we're dealing with a more sophisticated consumer than we used to, and this is becoming an avenue of recourse for them, and something that we're really going to have to stay on top of and deal with.
I want to stay on this more. I like this idea. Not the idea, but what you're talking about with a more sophisticated consumer. Is that the result of just people looking things up online? when they get a collection letter and trying to find, opportunities on how to, how to not pay it, or sort of what some ideas might be, to what do you attribute, this increase in sophistication?
I do think that there's a lot of that. I mean, it's much easier to find. You can go online, anybody can go online and find a strategy for how to deal with a debt collector. And here are the talking points you need to have if you're on a phone call. Here are the things you need to put in your dispute letter, your written dispute, whatever it may be. It's ubiquitous on the internet. You can find it. You don't need to engage in a credit repair organization or an outside attorney or something like that to really up the ante on your dealings with a debt collector. So I think a lot of that certainly is, the internet and getting the word out there and getting the news out there. And there's become a transfer of information on how to deal with those things and how to trigger your legal obligations and rights.
I think it's being driven by the push of credit scores over the cell phone. First, it was people signed up for Credit Karma, and then Credit Karma started capturing all the affiliate commission revenue for credit card applications. So companies like Chase and Citi and Capital One started offering free credit score monitoring with their accounts. And now there's sort of this battle to push a credit score to the consumer as regularly as possible to get them engaged with your content, upsell them on a different credit card or whatever it is and whatnot. And when people start quantifying their financial health by way of the credit score, we can debate the fallacy of that like later, but it's happening. Then everything becomes concrete, and they start to take their 674 and draw a line between that and the fact that RPM is reporting a derogatory account from Sequoia National Hospital, and then that becomes the focus. So I do think that the credit score push by these financial firms is actually causing a lot of this.
Is there maybe not so much a solution, but what would you recommend the industry's response to that? With is there an opportunity for them to to sort of participate in an education to kind of help maybe sort of fight the number of lawsuits that may come down the line, or is it best for them not to get involved?
Look, I think this is this is revolutionary, and people are going to be like, no. But I think that getting away from set piece templated scripts and letters that smell formy and spammy and insensitive, look, once you start credit reporting, it's like careful what you wish for, because you're going to get a lot of activity and you're going to draw a lot of attention to yourself. And there's going to be a lot of compliance risk too, but you're going to drive a ton of engagement. Now, all of a sudden, people are calling your office, but they want to have more sophisticated conversations. So, your $5 an hour collector that's been trained for 4 days and is only allowed to read a particular script is not going to form the kind of bond with that consumer that Judd talks about leading to a resolution. So, if I was running an agency today, I would probably reallocate my personnel budget, and I would take out sort of the human drone component of collection floors, and I would put in more the customer service. Are you speaking with a smile? That kind of stuff. And I would take away what I saw in so many collection floors as this subtle undertone of righteous indignation that, these people don't deserve to get a deal that we're giving them anyway. And I would replace it with people that come from call centers that are trying to upsell customers a new vacuum cleaner or a new vacuum bag. In other words, I would be giving them the 4-star royal treatment. And I think that leads to more resolutions. That's my prescription for the industry. Roll your eyes as you might.
I don't roll my eyes at all. I mean, I've always considered the best collector. Like if we were hiring someone, I value customer service experience over collection agency experience. I want somebody that's worked the drive-thru at Chick-fil-A.
And Brooke, to your point about call baiting, what Mike's talking about with sort of an educated collector may also help address those types of calls as well.
Absolutely. You know, it just comes to an issue of oversight. How do we make sure that they're following all of our policies and procedures? How do we score them? How do we make sure they're doing everything properly while still letting them just be human and, you know, speak to the consumers like a human, like customer service, like you would your friend. So it's always a balance as to how to oversee that and how to also just let them be human and talk to the consumer like they would anyone else.
One other area of FDCPA lawsuits we really haven't talked a lot about is overshadowing, also a common letter complaint. Wondering, you know, Joe, maybe you can sort of start the discussion on what you're seeing in terms of overshadowing trends and how best to deal with those types of lawsuits going forward.
One area that's interesting in overshadowing is out of New York and East Coast. The cases brought by the Barchet Sanders firm in New York and New Jersey. They had a kind of almost like a little bit of a business cottage industry going with their claim regarding their overshadowing claim lawsuits. They have really been, those have been bad for them. They've lost, we looked at several of them that they filed recently. I think that in the last year or so, about 14 or 15 of them were dismissed. They're just not working. These are letters that they're arguing that, for instance, the font size is not adequate. The location of the various notices and the validation rights are not situated properly. Lack of transitional language, that type of thing. So those have not worked. Those are really very, very hyper technical overshadowing claims. The ones that do work, though, are ones where our people really mess with the validation language. And we continue to see that. It's always amazed me that people at collection agencies feel that they want to try to improve on that validation language because it's just laid out in the statute. It's just something you got to put in your letter and leave it alone. Make sure you're adequately stating it exactly like the statute says. Don't try to improve on it. That's not your job. Your job is to put what the statutory language is in the letter. Get it out, let the validation period go, and then you can get creative with your letters, hopefully in a compliant way down the road. And I think going back to the model validation letter that we're going to see with Reg F, I think that's going to be really interesting because I mean, here we've got basically the CFPB telling us exactly what the language is supposed to be in this letter. Is that really going to work? Is that going to create a safe harbor that everybody's looking for to avoid overshadowing claims? Or is it actually going to are there going to be additional claims that are going to be based on this so-called, safe letter because it doesn't change the years of case law regarding overshadowing? So we'll see. I'm really curious about what the plaintiff's bar's response is going to be to that model letter. But that's a long way of saying that overshadowing cases are still out there. The picky little ones aren't really working, but if they are substantive, yeah, you've got to deal with those.
Okay. Anyone else want to chime in on the topic of what they're seeing with respect to overshadowing?
I haven't seen a lot, but I do have kind of a question, Joe, on how you left it, and Brooke, I'd be interested in your take as well. Outside of the letter type claims, are there more overshadowing claims based on collectors, comments on the telephone and in conversation? To me, maybe our letters have been vetted enough to where you don't have issues with the validation language on the initial letter. But I feel like as you get new collectors or less seasoned collectors, they're working out their probationary period and they're working accounts that are within the validation period. Sometimes they say the wrong thing. That still exists. It still happens sometimes, and they make some sort of immediacy demand for payment or something like that. To me, that I feel, from the outside looking in, that's more of a common type of claim than a letter claim. But I'm interested to see if that's the type of litigation you've been defending or seeing filed.
Well, I think it depends. I mean, many agencies will not try to make any communication with the debtor until the validation period is gone, over with. So if that's the way you operate, you're in good stead. But if if not, you're right. I mean, the collectors need to be very, very careful. And this gets kind of back to what some of the
Well,
points.
on inbound calls too. And
Yeah, you got that issue, right? Inbound, obviously. So, but that gets to the issue that Mike and Brooke were talking about, is like, how are you going to treat that consumer? Because if you're going to get in a heightened, contentious discussion with them about the debt, you're going to quite possibly have an overshadowing situation. Fortunately, it wouldn't typically be a class action situation where you might get you're going to have with letters, but yeah, those things can definitely occur, and we have seen those.
Personally, haven't really seen that many of those. I mean, the phone calls with a pro se consumer, they typically don't know what overshadowing is. Everything in writing they can take to their attorney, and their attorney can make a creative argument as to why that's overshadowing. But I haven't really seen it from the consumer collector standpoint that much.
We did get a question that came in when we were talking about standing, and before we wrap up, I wanted to address it. Do you think we will see federal courts start to award sanctions if a plaintiff's attorney continues a case through discovery, knowing that there is no standing?
I hope so.
Yeah, I don't think they will. I mean, sanctions are very difficult to get in federal court. I mean, there are always some outliers. You have Judge Sparks down in Texas that's hammered a few people, but the reality of it is sanctions are near impossible to get. And if you filed a complaint that alleges what gets you over the hurdle, and then your plaintiff doesn't end up giving you the testimony you need for that, then that's just it's too bad, so sad for the plaintiff's attorney, because he's not going to get his contingency. But you're not going to see judges sanctioning lawyers over that.
Okay. We've got a couple of minutes left. What I wanted to do before we wrap up, given the broadness of the topic, is give each of you a chance to share any last words, any concluding remarks, any parting words of wisdom, anything else you wanted to address with respect to the FDCPA that we didn't get a chance to talk about today, but just to give you all a chance to sort of summarize your comments. And Brooke, we'll start with you.
Thanks so much for having me. I guess to summarize everything I really kept saying was just prevent the litigation the best we can. Make sure your collectors are trained, go over your letters, talk to your clients about what's in their letters, because we're stuck with whatever mess they make for us. So prevention is the best thing we can do in terms of litigation.
Okay, excellent. Thank you. Joe?
I guess what I'd say is, I think if you're going to do business, if you're going to be a collector, you got to be malleable. You got to be constantly changing your procedures to try to deal with the new theories of liability that are coming out. Make sure that you are attending events like this, any educational information that you can get, or webinars or conferences you can go to where you can soak in that information and make the changes. It's just part of the job. I mean, because if you stop and don't keep innovating and progressing in your compliance, you're not going to know about something that happens. Like I mentioned, that those FCRA claims that are popping up, you're not going to be aware that those things are occurring, and you're going to be the next person to get hammered. So it's just a necessary evil, and we do appreciate the opportunity to share what we know and the experiences we're having, and really appreciate that you put these webinars together, Mike.
Excellent. Thanks, Joe. Mike?
I want to warn against an attitude. And it was topmost of my mind when I was a debt buying owner and a collection agency owner, and I worked as a collection attorney. And, there is a whiff of it in some of these panels that we do. And it's just to sum it up in sort of a blunt and brutal way, it's that, all these cases are BS, and all of the plaintiff's attorneys are BS. And it's very, very dangerous to adopt that cavalierly, because what you do when you do that is you dehumanize a certain portion of your debtor base, of your consumer base. When you get portfolios, you think, all right, I'm going to give everybody a fair shake and they've got an opportunity to pay. But once that consumer files suit, they go into the it's all BS bucket, right? I've identified a litigious debtor, and they all their claims. And that over the course of litigation can really drive you under, because there are firms that are being very selective about FDCPA cases and filing ones that have solid actual damages and that are worth, 5 to sometimes you'll see 7-figure verdicts, not that they don't get cut down. But it's this cavalier attitude that comes out early in negotiation and through the discovery process. And then once we've done depositions, the parties are so entrenched in their attitude about the case that they continue to pile on and go sort of over the cliff. So I would just warn everybody on the webinar, maybe some are, maybe most are, I don't know, but be careful that you don't think all are, because those could leave you hanging out to dry and a little bit poorer than you would be otherwise.
Good advice. Judd?
I think my best message in a takeaway sense, my prognostication for FDCPA litigation in the future, once Reg F becomes not enacted, but becomes enforceable next year, 2022, I think there's going to be a real boom in FDCPA litigation, just because they're going to be testing how that's to be interpreted in which different courts, and applying real-time debt collector conduct to what is required under the new regulations. So I really think that that's going to be a swell of FDCPA litigation until we kind of arrive to a steady state of what is and is not allowable. It's going to have to be interpreted in courts, and we're going to be stuck with a lot of litigation to get to that interpretation.
Excellent. Well, Brooke, Judd, Joe, Mike, thank you so much for your time and your expertise and sharing that with our audience today. On behalf of everyone who watched and listened, a great thank you to each of you. Really appreciate it. Also, a final thanks to TCN for sponsoring today's webinar. Please check them out at tcn.com. There's a link in the chat window, and one should also pop up on your screen when I end the webinar to share your feedback about today's event. So I encourage that. There's also a way to submit any ideas you want to see come in a future webinar. I'm planning June's webinars right now. So if there's something you want to see covered, that's a great way to share your thoughts with me, and you'll likely see it on the calendar next month. We're back tomorrow talking about where to hire, how to find quality candidates today. I know that's a problem that a lot of companies are going through. And then we're going to close the week out on Friday with a discussion on charitable giving and community service in the arm industry and how to do more of that. So hope to see you for those. If you haven't signed up, there's links in the events calendar on accountrecovery.net for both of those. So we'll hope to see you then. Until then, everybody have a great rest of your day. We'll talk to you tomorrow. Panel, thank you so much. Great job.
Thank you.
Thanks.
Thank you. Bye-bye.